Good afternoon, everybody, and thank you for coming back. This is Disability Pride Philadelphia. Today, we're going to be talking with the Philadelphia Commission on Human Relations. I am Vicki Landers. I am the Executive Director of Disability Pride PA. I am a white woman, and I have purple and teal in my hair. I am wearing tortoiseshell glasses and a black sweater. I have tons of fun stuff behind me. And we are so happy to be doing these today, the virtual day of advocacy. I've asked that the Philadelphia Commission on Human Relations join us today because I believe that we need to know more of what they do. That when we're talking about advocacy, that they are one of the first lines that we can use to advocate for ourselves. So I'm really happy to have both of you here. We also have Rita Joe, who is our interpreter for the day. So thank you, Rita. So with us today is Karen Foreman, an attorney with the Philadelphia Commission on Human Relations. And also we have Pamela Gwaltney, the Deputy Director of the Compliance Unit. Thank you both for joining us today.
Thank you for having us.
Absolutely. Like I said, I don't believe enough people know how important you are and how important your commission is in the advocacy work that we all do for ourselves and for others in the community. So I'm really excited to have everybody learn a whole lot more about the things that you do. So I'm going to come off screen. I'm going to let the three of you have a conversation. I'm also going to pull up a presentation that they'll be doing. And the presentation will be available for anybody who needs that afterwards, just so that way, in case you have some questions or you were not able to see the PowerPoint thoroughly. All right. So yeah. I am going to leave you all, and I will see you all soon.
Okay, good afternoon, everybody. Thank you for having us. My name, again, is Karen Foreman, and I'm an attorney with the Commission on Human Relations. We're a city agency. We enforce the civil rights laws of the city of Philadelphia. Again, the name of the agency is the Philadelphia Commission on Human Relations. First slide, please. Next slide. So we're a city agency. We were established in 1951. We're the first municipal agency to enforce civil rights laws in the country. The law that we primarily work under is called the Fair Practices Ordinance, and that law is included in the city code. So we have really two functions. We enforce the civil rights laws, and we bring people together across differences. We have another unit that goes into the community to address disputes between neighbors and address hotspots, things that, like, if our staff believes something is brewing in a particular part of the city, they are available to address those disputes or those brewing disputes. Next slide. So the Fair Practices Ordinance is actually a very strong law. It prohibits discrimination in employment, in public accommodations, which a public accommodation is any place that's open to the public, or a service that's open to the public. We enforce the anti-discrimination laws in housing and real property, and access to city services. The law applies to employers. It applies to anybody doing business within the city of Philadelphia. It applies to housing providers, property owners, and the city government. And any person who believes they've been harmed, discriminated against, in violation of the Fair Practices Ordinance can file a complaint with our agency. And we'll address that complaint. We'll investigate that complaint if it falls within our jurisdiction. Next slide, please. So the way these investigations are set up is the party that is filing the complaint, the person who believes they're being harmed or discriminated against, is called the complainant. And the person or business or any entity that against whom the complaint is filed is called the respondent. Next slide. Our role is to investigate complaints that are brought to us, and we collect information to assess whether we believe that there's evidence that shows that there was a civil rights violation. If we believe that a violation occurred, our agency can conduct a public hearing, and then our commissioners can draft an order. It's a written order, as if it's like a judge's order, and they can order remedies if the party bringing the complaint proves at a hearing that the discrimination actually occurred. Many, if not most, of the cases that come before us are settled or conciliated before the claim or the conflict goes to a hearing before our commissioners. We'll go into more detail about all of these things. Next slide, please. We are neutral. PCHR, the Commission on Human Relations, is a neutral agency. We're not anybody's lawyer. We don't give legal advice to particular parties, and we don't prosecute the cases for the complainant or represent the respondent if a complaint is brought against them. We're neutral. We're the neutral agency. Next slide. Thanks. So what's discrimination? Discrimination is when a person believes they are being treated differently, worse, than people who are outside of their what's called a protected class. It could be an actual protected class or a perceived protected class. We'll go into more detail about that. But what that means is that any unjust treatment really does deprive a person of equal opportunity to employment, to housing, to use of public accommodations, which may include schools, universities, colleges, and that's generally what discrimination is. And in order to bring a claim, the alleged harmful act, the harm, has to be within our jurisdiction. Next slide, please. So not all unfair treatment qualifies as unlawful discrimination under our law, under the Fair Practices Ordinance. In order for us to accept a complaint for investigation, we have to be satisfied that we have jurisdiction over the matter. It has to be the harm has to take place within the city of Philadelphia. And go to the next slide. I think it identifies. Well, go back to the other slide. I'll continue with that. It has to take place within the city of Philadelphia. It has to meet certain requirements. So again, not all acts of harm, not all unfair treatment are unlawful under our law. And so we can't accept and investigate every claim that is brought before us. Next slide, please. So in order to qualify for us to investigate a claim, the individual who's bringing the claim has to be within a protected category. Those protected categories are listed here: race, ethnicity, sex, sexual orientation. This list, it includes disability, and within disability, it also includes perceived disability. And that means that even if somebody is not disabled, if the person or the entity, the business who is causing the harm believes a person is disabled and causes harm on the basis of their belief, then that may be a discriminatory act. This is our list of protected categories. Next slide. So the Fair Practices Ordinance, the actual law, it is included in the Philadelphia Code. The Philadelphia Code includes all the city laws. Our law, the Fair Practices Ordinance, has actually more protections than federal or state laws. We protect people from in the category of source of income, which means that it's applicable to housing. That means that a landlord can't discriminate against somebody whose source of income is public benefits or child support, or some other source of income other than employment. It also includes breastfeeding in public places. Those categories are not included in the federal law, for example. It specifically protects people based on their sexual orientation and gender identity. And our law covers all employers with one or more employee. The federal law covers employers with 15 or more employees, and the state law covers employers with 4 or more. So our law, the Fair Practices Ordinance, is actually broader than the state or federal law. Next slide, please. So here are the legal requirements for filing a complaint. The conduct has to have had taken place within the city of Philadelphia. The complaint must be filed with us within 300 days of the date that the discriminatory conduct took place, the alleged discriminatory conduct took place. So we can't investigate a harm or an incident that occurred 2 years ago. It has to be within the last 300 days. And the complainant, the person bringing the complaint, has to establish that the harm, the conduct that they believe is discriminatory occurred because of their membership in their protected class. Which means that we need to see the connection between the harm that took place and the protected category. And we'll go into that a little bit more in the next coming slides. Continue, next slide, please. So the ways of thinking about discrimination, we call those theories of discrimination. Those are essentially ways of thinking about how discrimination may take place. The first one is disparate treatment. And that's very direct intentional discrimination, when a person or an entity intentionally treats one person worse than another person or somebody outside of their protected class. And examples are a landlord failing to rent to Black or Latino applicants who have a criminal record, but does rent to similarly situated white applicants that have criminal records. So the people who are Black or Latino are treated worse than white applicants who are both of whom have criminal records. Or another example is that an employer promotes male employees but doesn't offer the same opportunities or promotions to equally qualified female employees. Or a restaurant, a public accommodation. A restaurant is a public accommodation that has a sign out front that says only Americans are welcome to dine. Being an American is a national origin, and that is a protected category. Next slide, please. Another way of thinking about discrimination is called disparate impact. And that's when there's a neutral rule or neutral policy or practice that has a greater impact on members of a protected class. So, for example, if a landlord's policy of refusing to review applications with of people with criminal records disproportionately impacts Blacks and Latinos, then we say that policy, that rule, has a disproportionate impact or disparate impact on Black or Latino applicants. Another example is an employer's a neutral exam, for example, a psychological test that all applicants are required to take, but it impacts female applicants, more harshly, and it results in female applicants being excluded from a particular job because they underperform on a particular test. So everybody has to take the test, but it impacts a group more harshly than another group. Next slide, please. Another theory of discrimination, another way of thinking about discrimination, is harassment. So harassment is when somebody who's a member of a protected class receives unwelcome conduct, harsh conduct, or comments that are directed towards them based on their protected class. And that it has to be, it's not just one comment or one incident. It has to be what's called severe and pervasive. It means that there's like a pattern of that occurring, and it happens frequently, so it creates what's called a hostile environment. And it really just rises to a pattern, and it interferes with a person's ability to do their job properly or live in their apartment without being disturbed all the time. And examples are an employer could create a hostile environment if they allow mocking or bullying of a particular person based on their membership in a protected class, based on their disability, based on their race. And that pattern of conduct, that repeated conduct or repeated comments creates a hostile environment. And what that means is when you think about going to work, you just like can't even bear to think about going to work. Another example is that a public service employee, a city employee, for example, denies a service to an applicant by making sexual advances and refusing service unless that person submits to sexual advances. Next slide, please. Another way of thinking about how discrimination takes place is retaliation. And retaliation in the area of discrimination, it's a little bit more narrow than general acts of retaliation in the broader world. It requires that somebody takes an action against some individual, some adverse action, because is after the person either stood up for themselves by calling out discriminatory activity or filing a complaint on behalf of themselves, or try to protect the rights of others by, for example, acting as a witness. So, for example, if a landlord evicts a tenant after a tenant files a discrimination complaint, that act of eviction is retaliation because it came on the heels of the tenant filing a discrimination complaint. Or in the employment context, where an employer can demote an employee after that employee agrees to be a witness for a coworker who filed a claim. Next slide, please. So the process of filing a complaint is pretty straightforward. Complaints could be filed by mail, by fax, or in person. And right now, since the shutdown, since the onset of the pandemic, we are accepting complaints by email. The complaint or the information presented to us has to have certain information. We have to have the correct name of the person or entity that caused the discriminatory harm. And we need a description of what happened, the conduct, the incident, the policy, or anything that creates the discriminatory act. And the way we start this process is by the complainant, the potential complainant, completing a questionnaire. And it asks our questionnaires ask very specific questions so you could zero in on the information that's required. And those questionnaires are actually called intake forms. And anybody who needs assistance, right now, our office is open. You can contact us. We don't have our elevators open right now, but we are here. We are entertaining phone calls. We will come down to the lobby of our building. We assist whoever needs assistance completing an intake form. And we can accommodate anybody with any type of disability who needs assistance completing the intake form. Next slide, please. After a complaint, what happens is after a complaint is submitted, after the intake form is submitted to us, our staff drafts a formal complaint. And the formal complaint sets out the discriminatory actions in a very specific kind of a formal format. And we will draft it on behalf of the complainant. Sometimes if a complainant is represented by a lawyer, which is not necessary, the lawyer will submit a drafted complaint, or we will draft the complaint on the person's behalf and send it to the potential complainant for their review. It is their complaint. It's the complainant's document to make sure that it says it conveys the information that they intend to convey. The commission will then, once they sign it and send it back to us, we serve it on the respondent. And then the respondent, which is the entity, the business, the housing provider, the city service, they must respond within 28 days. Often a respondent needs a little bit more time to prepare an answer, and we allow extensions. They have to contact us. We have to know that the respondent has received the complaint and intends to respond. And if they contact us with a request for an extension, we often give that extension. But the respondent must comply with the investigation. That means that they have to respond with any documents that we request, or it could lead and request for interviews, request for any kind of information that our investigators request to determine whether or not there's substantial evidence that discrimination occurred. If a respondent doesn't comply, if they believe that they could just walk away, there are actions that we could take. We could take what's called a default judgment. That means that if a respondent doesn't comply or answer the complaint, the allegations against them are deemed that they are admitted, that we assume that they admit anything that they don't deny. And the complainants likewise have to submit all information that is requested. So the investigator that's assigned to the complaint is really the main contact person for collecting all of this information, and both parties have access to the assigned investigator throughout the investigation process. Next slide, please. So after the investigator collects all of the information that they believe they need to review based on what the allegations, what the claim is, the allegations of discrimination are, then they review it and we evaluate whether the evidence shows that there's that it is more likely than not that discrimination occurred. And they look at everything that has been submitted. Sometimes even the investigator could go make a site visit to the location where the alleged discrimination occurred. Next slide. So after all the evidence is collected, then the commission reviews it. The investigator works closely with supervisors, works closely with our Deputy Director, Pamela Gwaltney, who's here today with me. And we review all of the evidence that is collected, and a determination, a recommendation is made. It could be if the evidence reveals that it is more likely than not that the conduct wasn't due to the individual's protected category, then a recommendation of no cause will be made. And that means that it doesn't mean that it definitely did not happen. It means that we didn't see it. But if after all the review of all the evidence reveals that the alleged discriminatory conduct was due to that individual's membership in that protected category, then the staff makes a recommendation of what's called probable cause. And that really means that it is more likely than not that discrimination did occur. If probable cause is found, it doesn't mean that the complainant has automatically won the case. What it means is that there's enough evidence to proceed to a hearing before our commissioners. Next slide, please. So throughout the investigation, the commission encourages parties to settle the cases. This settlement could occur in a variety of ways. Sometimes the parties talk to each other through a mediation process, and that means that a neutral third person facilitates a conversation between the parties. And the parties talk to each other, and if they could mutually agree to a settlement that both sides are satisfied with, the case could be settled. If that settlement occurs after the commission finds probable cause, that process changes a little bit. That's called conciliation. And that means what happens then is, in addition to both parties agreeing to the settlement, the Commission on Human Relations, our staff, our commissioners, have to agree to the terms of the settlement as well. So we encourage parties to settle at any time during the process. Next slide. So how long does it take? This is not a quick process. It usually takes a few months or several months. If a case is settled, that could happen within a few weeks. But full investigations often take months or sometimes years. Our staff works to investigate older cases first, and then and cases that are deemed to where there's probable cause that discrimination occurred will be heard by our commissioners before the newer cases. But at any time during the process, a settlement could occur. Next slide, please. So if a case proceeds to a hearing, if there's probable cause is found and a public hearing is held, then the hearing is held before our commissioners. It is, in some ways, it's like a court hearing. In some ways, it's much less formal than a traditional court hearing. The hearing panel, it consists of our the PCHR commissioners. They preside over the hearing. Most often, the parties are represented by counsel, but counsel is not required. And if a party is not represented, the commissioners will address the unrepresented parties directly. And again, it's really worth noting that the commission, our staff, doesn't prosecute the cases. We are neutral. But during this hearing, the parties have to present evidence, witnesses, documents, or direct testimony that shows that the discrimination occurred. The complainant has to prove their case before the commissioners, and they have to show what relief should be sought, should be granted to them. And then the commissioners write a decision, and a decision like a judge, as if a judge would write a decision. If they decide in favor of the complainant, the decision will include appropriate remedies. What it includes is to put the complainant back in the place where they would have been if the discrimination didn't occur. It could be money. It could be orders to do something or stop doing something. We'll go into that a little later. But any ruling that the commissioners write can be appealed. It's appealable to the Court of Common Pleas, and either party could appeal. If a dissatisfied party wishes to appeal, they can. Next slide. So here are the remedies. Here are the things that commissioners can order to put the complainant, the person who was discriminated against, back in the place that they were as if discrimination had not occurred. They could order what's called compensatory damages. That means reimbursement, it's money, reimbursement of any out-of-pocket expenses that occurred resulting from the discriminatory acts. The commissioners can order what's called injunctive or equitable relief. That means that they order the respondent, the business, the housing provider, to take certain steps to stop the discriminatory practices. Sometimes punitive damages are ordered. Punitive damages can be ordered up to $2,000. And that is a punitive damage order. Could be ordered if the commissioners believe that the respondent acted intentionally and repeatedly, and it's an additional amount of money to act as a punitively, like a punishment. That money is it's a fine. It doesn't go to the complainant. It's as if the respondent has to pay a fine, and that money goes to the city of Philadelphia. The commissioners can also order attorney's fees and any costs that counsel, the attorneys, state or submit, petition that requests the amount of money that they are asking in payment. And again, the penalties, the certain penalties like punitive damages, goes to the city of Philadelphia. That $2,000 doesn't go to the complainant. It goes to the city of Philadelphia, as opposed to the compensatory damages, which goes to the complainant. That reflects any financial losses that the complainant actually incurred. Next slide. So in addition, most recently, as City Council has seen fit to pass additional laws, additional ordinances that our commission enforces. And here's a list of those laws. The gender neutral bathroom law, which kind of speaks for itself. Bathroom entities must have a single stall with a gender neutral identifier. The Fair Criminal Records Screening Standards Ordinance, that people refer to it as ban the box or the Fair Chance Hiring Ordinance. And that provides that people who have a history of criminal records, when they apply for jobs or when they're working in being considered by employers for promotions within their job, they are considered on their qualifications, their skills, their merits, and not on their past criminal history. So the employer can't look at a criminal record until for the application process after an offer of employment is made. And that is just to give a person with a history of a criminal record a fair chance at a job that they're qualified for. The other laws, unlawful credit screening, some applicants, some jobs, they can't use a credit report, credit score as a condition of employment. Another one is what's called unpaid leave for domestic or sexual violence. That ordinance provides that anybody who is a victim of domestic or sexual violence may take off time from work to address their needs related to the domestic or sexual violence, like find a safe place to live or get medical attention or seek legal action. The next one, the cashless ban. It means that entities in the city, businesses in the city must accept cash, can't only accept credit cards. The wage equity ordinance requires that you can't ask an applicant what their most recent salary was as part of the process of determining a salary in a position, because what happens there is if somebody is in a member of a protected class, for example, women who traditionally throughout history make less than men. If an employer wants to give that the woman that they're hiring a raise, and they just base it based on their most recent salary, and they increase that salary 10%, then the similarly situated man who has a higher salary in their last job gets also offered a raise 10%. The woman would still be behind 10%, and it just reinforces a history of unequal wages. Our Do Not Solicit Ordinance is an ordinance that protects homeowners by being solicited by people who are called wholesalers, who really use predatory tactics to try to purchase somebody's home for a value that's really under what the home is worth. Renters access is an ordinance that requires landlords to adhere to certain criteria when looking at an applicant's qualifications to rent an apartment, or rent a house, rent either an apartment or a house. But what they have to do is they have to post the qualifications that the applicant requires, so that they can't ask some people for a credit report and say not others. And then the final one is the prohibition against pre-employment marijuana screening. What that ordinance requires that employers not do pre-employment testing for the presence of marijuana in somebody's system as a condition for employment. And that's only at the application, the pre-employment stage. So that's a list of the other ordinances that we enforce. And if you want more information about those, they're on our website, or at a later time we could talk about those. Next slide, please. Thank you. We're done. And now we could take questions. Pamela Gwatley and I can entertain any questions you may have.
Hi, thank you. See, this is why I needed to have your commission come on and talk, because I definitely learned a lot.
Good.
I'm thinking back. I'm like, really? I'm like, wait, I could have used that. And I'm sure that there are folks out there. I have a question. I'm gonna take this down here. And if anybody wants this information, just please let me know, and I'll make sure that you get how to contact them. So my question is about the pre-screening for medical marijuana. Well, marijuana screening, I guess, in general. And then the medical marijuana screening once you're asked about your job. You know, they can say, hey, you can have the job, but we need you to be screened for these drugs. And somebody has a medical marijuana card here in the state of Pennsylvania. How does that work? You guys?
Maybe you want to take that one?
Sorry, it's a huge thing.
My pleasure. So we have been asked to enforce this legislation, and we are presently working on regulations because the legislation basically has more exceptions than it does those who are covered by the actual legislation. The intent was to protect individuals who use medical marijuana. However, this was not written into the title of the legislation nor the intent of the legislation. So there are employers who are going to be able to pre-screen employees because the jobs are of a public safety concern. So in other words, they would need to have individuals tested because they can't have folks driving who would be under the influence, or folks handling heavy equipment, tractors and such, welders. So there are certain positions where employers will have exceptions. There are some set forth in the legislation, and in our regulations we'll be setting even more. However, as it stands right now, employers should not be issuing pre-employment testing for marijuana. What they will do is, if someone decides that they're going to want to apply for a position and the employer is testing, they can contact us. We can speak with them about the possibility of filing a complaint. We'll also attempt to let you know at the time you contact us whether or not we believe that the position may very well fit into one of those exceptions. And also during the time that we create the regulations for employers as their guide, we would not be penalizing employers, but instead providing information to them with regard to the legislation. But we encourage you to contact us and reach out to us with regard to this brand new legislation.
Yes, there's so much. There's so many questions that people are having about it. And so in pre-employment, they're not allowed to ask. Now, once they've offered you the position, they're allowed to screen whatever they want? Or
yes, once you are offered the position, employers, and you then officially become an employee of the company is going to have its own internal regulations with regard to marijuana testing and other drug testing. At that time, if you are on medical or an individual is on medical marijuana, that is the time that they would present the card and have conversations about a reasonable accommodation.
Thank you. Those are my favorite words, the reasonable accommodation.
Yes. I mean, I think we received a case recently where I think that the applicant for the position may have done themselves some harm by coming right in gangbusters at the door saying, look, I've got this medical marijuana card and I'm allowed to, use marijuana. We would encourage you to handle yourself professionally as you would at any other interview. And just as there are certain things you don't discuss at the time of the interview, unless it presents itself as a need that you should do that, then bring that up. But there are other types of questions which you wouldn't want to bring up or volunteer at an interview. For example, age. If you're over 40, it's no one's business how old you are. You're there as a qualified candidate for the position. You don't need to have a conversation about your age. Anything that would lead someone to discover how old you are. If you don't have years of graduation or your resume, or if you decide that you don't want to share that information, you don't have to share that information. If you have young children at home and, you believe that you feel like the potential employer needs to know that, I would ask you to rethink that. Does the employer really need to know that about you at this time? Or are they just there to find out whether or not you are the best qualified candidate for the position? So the same thing would go with the medical marijuana. That would be a reasonable accommodation for you, or if the time came and they wanted to test you after they offered you the position, that's when you engage in the discussion. But I would recommend that you not do anything to set yourself back with regard to being considered a qualified applicant for the position.
I tell people this all the time, is that when you go into an interview and answer their questions.
Yes. It's not a confessional. It's not a confessional.
Right. Don't give more than you.
No, it's because in the long run, it's not going to end up serving you, and you may very well be needing to give us a call and have a conversation. So go in as prepared as you can be. It's not a confessional. They're not your friends. They're there to find the best possible candidate for the position. And you very well might be that person.
Yes. I always find that when I'm talking to people about building resumes and having these conversations, going to interviews, that giving that kind of information, those little pieces, trying to make yourself personable to somebody, also puts it in their head of, oh, well, maybe this candidate would be better because they have this.
Right.
So I'm always.
Exactly. I think that's great advice, Vicki.
Thanks. One of our people here said, thank you so much for all of this information. It's really great. They also said, very good advice.
You're welcome.
I think it's super important. I know that with COVID and housing, and then the forgiveness period that they extended and then they stopped it. I know that there were so many questions about people being evicted or why they were being evicted. And I honestly, I told people, I'm like, well, I think you need to go and talk to.
Yeah, fair housing.
Yeah.
We are under the same umbrella.
Mm-hmm.
We have the same executive director. They are staff that has a very particularized expertise with regard to recent legislation that has to do with evictions. And so, maybe that's another presentation that we might want to consider having with the fair housing to specifically talk about tenant and fair housing issues. We're not those folks, but
it's a separate.
Talk about discrimination with regard to housing. We're your people, but fair housing and landlord-tenant issues,
right,
they would be the go-to folks for that.
Yeah. I had somebody who called last week who said that they went to go see an apartment. They are a wheelchair user.
Yes.
And the space was accessible for them to be able to rent the apartment, and that the landlord basically told them that their wheelchair would cause too much damage. So,
They could call us. We encourage people to contact us. Yeah,
give us a call. Of course, we can't make guarantees.
Yeah, no guarantees, but
give us a call.
It's those kinds of things are worth a call, worth a discussion with us, and perhaps filing a complaint.
Yeah, that I just it blew me away. I mean, we understand in the city that there's not enough accessible housing, mm-hmm. and then to find something that was accessible, but because of that, I just was like, no.
Yeah, no, that's the first thing I thought too. No, please don't say that.
Yeah.
Our intake form includes a question that says, right at the end of the intake form, after you give us the information, it says, do you definitely want to pursue this complaint, or do you want to talk to somebody before you decide for sure whether or not you want to pursue this complaint? And if you check that second box, we're happy to discuss it. Sometimes it is worth somebody's while to pursue it, and sometimes a person decides not to. But we're willing to we're happy to have that discussion.
Right. Yeah, I think that that's one of the things that I wanted everybody to get out of this, is that these things are worth having a conversation, mm-hmm. and you are here to have that conversation.
Yes.
And we're talking about advocacy throughout the day, and we talk about it all year, but trying to really hone in on some of the advocacy pieces. Mm-hmm. And for me, because disability pride, I find that if you are proud of yourself, you advocate for yourself, and you start to advocate for others, and then you're advocating for your community.
Absolutely.
So some of the things that I hear is that people don't know where, mm-hmm. when they have things going on. they don't know where to go, and you get a lot of misinformation, and folks are too easily jumping to I need a lawyer,
Yeah.
instead of using the resources we have here in the city. Who
Absolutely.
are you?
Yes, there are lots of advocacy organizations that are willing and ready to help and to provide information.
So thank you so much. The one last thing I had to ask is that since my organization is Disability Pride PA, so we have folks all over the state that talk to us.
Yes.
They should be able to find a commission in their areas.
Yes, the Pennsylvania Human Relations Commission is the statewide civil rights agency, and they accept complaints with basically the same protected classes as us. And so, if you are not in Philadelphia, certainly give them a call, and that's the Pennsylvania Human Relations Commission. They have a Philadelphia office, they have a Pittsburgh office, they have a Harrisburg office.
Look at that. We are actually doing Disability Pride here in Philadelphia this week, as we all know. We are doing our first Disability Pride Pittsburgh event in July, and then one in Harrisburg in October. So
great.
I want to be able to spread the word, and I just think it makes us better advocates when we know of where we can
absolutely
ourselves. So thank you both.
You're welcome.
Coming in today. Again, this is why I asked, because I thought that I know that you guys have great information, and I still learn something, which is really great.
That's good to know. It's a pleasure to be here with you today.
Yes, thank you so much for having us. And we're available for questions. You could give people our email addresses.
Yes. I'm going to put that back up here for people to see. Let me take yes, people in the chat are saying super informative.
Great.
Good advice. Thank you. Yay. What to do.
Awesome.
Thank
you so much for having us.
Of course. And I'm going to put this information up on our website for those folks who need it. And remember, if you didn't catch the whole presentation, it is here on Facebook with all of you. You can also catch it on YouTube, Disability Pride PA. Thank you, everybody. Thank you again, Karen.
Thank you.
And then always thank Rita Jo for interpreting today. We will see you all at 2:00. We're going to talk to the Mid-Atlantic ADA Center about what the ADA says about voting and access. See you all later.
Bye, everybody.
Bye.
Bye.
Thank you.